Hi, and welcome to this episode of HR and Cocktails. Today, I am joined by Sarah Sawyer. She is a partner at the law firm Offit Kurman. Welcome. Welcome to the Speakeasy.
Yeah, thank you. Thank you so much for having me.
Yes, absolutely. So today we are going to talk about the ever important topic of the Fair Labor Standards Act, the new overtime rule, the salary threshold, as well as non-competes. Okay, so Sarah, you and I have talked several times, and you're an employment attorney. So you get the privilege of working with many organizations to help them with their employment matters. Compliance is definitely, I'm sure, a large part of it, correct?
It is, yes.
Yeah. So recently, the Department of Labor made some changes to the salary threshold for the exemptions for overtime. So before we get into the depth of that, can you first tell us about you and your role at Offit Kurman?
Yeah, so I'm a principal and department chair at Offit Kurman, and I serve as an outside general counsel for my clients, middle market businesses, owner-run and operated businesses. And in that role, I handle employment matters, very frequently counseling employers on compliance, and then also helping them through issues when they do get sued or they have a complaint filed against them, everything hiring, firing, all types of compliance issues and the like.
Yes, awesome. And for people who aren't like us, this is fun stuff, right? I really love it. I love everything about employee relations and compliance and all of those things. And there are people who don't love that, so they call us. And so that's great. So
yes.
We get to have fun doing the things that are fun for us. And while the changes to the Fair Labor Standards Act are huge, and I know they're the final rule, I will talk about why I think that might change. But before we kind of get into the details of the changes, can you talk to our audience about what the Fair Labor Standards Act is?
Yeah. So the Fair Labor Standards Act is what you think of when you think about overtime. So it dictates who gets paid overtime and who doesn't. The default is that every employee is what we call non-exempt and entitled to overtime under the Fair Labor Standards Act. However, there are, if we're calling someone non-exempt, that means there's probably exemptions, right? So there are a number of exemptions where employees may not be entitled to overtime. So that's really the most frequent context that people are dealing with this in. And there's two things to consider when deciding whether someone is exempt or non-exempt. Folks sometimes forget that there's two things that you need to consider, and that's the salary basis test and then also the job standards piece of it as well. So the salary piece is what we'll be talking about a little bit more at length today. And then the job duties test is, does this employee perform certain types of duties that would make them exempt? So executive, professional, administrative, highly compensated. So think, I'm not an assembly line worker, I'm managing people in the office, or I'm an executive being paid a lot of money, those types of things.
Yes. And I mean, the Fair Labor Standards Act does call out specifically that they're white collar exemptions. Yep. And I think it's also important. So let me say this. I have lots of things to say about the decisions that the Department of Labor makes, but the fact that they have not changed the name of the administrative exemption, I just feel like it's such a misnomer because it makes people think that they can lump people into that administrative category if they don't really look at the true details of what's included. So, I mean, if DOL, if you're listening, can we change that? Just change it to like something else other than administrative exemption.
Yeah.
So yes, the duties test is really important. But prior to this conversation, that was the thing we really harped on. It was like, make sure that people can pass the duties test. But now we have a significant change to the salary threshold under the salary level test. So can you talk a little bit about what these new changes are?
Yeah, and I will pull out my cheat sheet in a moment because there are lots of numbers involved here. So there is the salary basis. I'll talk a little bit about what the salary basis means, and it means that you have to be paying an employee a consistent salary, so that implied in the name, as opposed to an hourly wage. So they have a consistent salary regardless of how many hours they work in a week. The goal is that you're compensating them, and it's however many hours it takes to get the job done, right? So in the past, there's been several different, what that minimum threshold of what the salary per week needs to be for them to meet the salary basis exemption. And there's going to be, as you alluded to, a very large change in those numbers and what is going to qualify. So between now and July 1st, an employee needs to make $684 a week, or roughly $35,508 per year in salary to be exempt. Obviously, also have to have the job duties test that you alluded to as well. Well, now starting July 1st, it's going to go up to $844 per week, which is $43,888 a year. That's a huge difference. I mean, almost a $10,000 difference.
Yes. It is. It's huge. And there's going to be another jump in January. But before I can wrap my mind around all of that, we need to get a cocktail. Yes.
Whenever you're talking numbers, I think a cocktail is helpful.
Exactly. So which cocktail would you like today?
Aperol Spritz is my favorite.
Okay, awesome. And Aperol Spritz coming up. Sarah, you chose an Aperol Spritz for your drink. So tell me why you selected an Aperol Spritz.
Well, a lot of it has to do with the timing. So we're getting near summer, and this is my favorite summer drink. It's nice, light, refreshing, a little bubbly, something you can have a few of if you're hanging by the pool, which I hope to be soon.
Yes.
So it's a interesting taste, just kind of a fun, light drink. I like to switch from red wine to white wine when I get into the summer, and so Prosecco is the perfect type of cocktail.
All right, awesome. So we will get started. So as you all know, stemware is very important to me. So you have to use a large wine glass for this. We've already put our ice in it. Yes, we've already put our ice in it. So we're going to get started with our Prosecco. I used small bottles because I will tell you that Prosecco champagne, it just doesn't hold well. So, and it's supposed to be 3 parts. I'll be honest with you, measuring that is just not that easy to do. So we're gonna eyeball this thing and just pour some in there. We're just gonna pour some in, and I think we need another one. I don't feel like that was 3 parts. I don't think we have enough.
I mean, you need the bubbly.
You definitely need the bubbly, for sure.
Bubbly is the celebratory part of the drink.
So if you're measuring and you feel so inclined, it's 3 parts. 3 parts of champagne, or you can eyeball it. And then you're gonna do 2 parts of Aperol, which we will do. And I will be honest, Sarah, Aperol for me is a bit of an acquired taste. It's a very refreshing drink, but I'm gonna have to add a little bit of fruit juice to mine just to sweeten it up a little bit. But listen, it is a very popular drink. People really love it. And it's a very, very refreshing drink for the summer.
Well, that champagne does help cut the bitterness of the Aperol for sure.
It does.
Whoever created this drink
knew what they were doing. Exactly. So we're gonna top it with some club soda, just a little bit to add a little more fizz to it. All right. It's very pretty. It looks like an Aperol
It looks like the right
Spritz.
color. That's how you tell if you're doing it right. It's the color.
Exactly. And then I got a little tropical fruit nectar. I just got it from the international section. So I'm just gonna put a little in here for me, or spill it. I'm going to do either one of those. Would you like to try?
I am going to try. I'm going to try the twist.
The twist on it.
This might be my new way of doing things.
It may be. So let's try it. All right.
Cheers.
Okay.
I like that. I like the addition. I like the twist.
Awesome.
Cheers.
Thank you. So now that we have our drinks, cheers.
Cheers.
And I forgot to add the orange when we were making it. So before we walked in, I added the orange for garnish. So please do that as well. As we were saying before, there's going to be a change in July to the salary threshold, and then another proposed change 6 months later in January, which is an even bigger jump, correct?
Yeah.
So can you tell our audience what that new jump is in January? Yeah,
and it'll be in January, so you're not going to have much time to adjust. So really, when thinking about any changes you're going to make, you want to be thinking about the January number, in my opinion, because why you don't want to make two changes.
Exactly.
And so if you're trying to decide whether you're going to keep someone classified exempt or move them to non-exempt, it's a numbers game deciding about overtime. And you want to we'll talk a little bit, I'm sure, about that, but you want to focus on the January number, which is $1,128 per week. Mm-hmm. So just to recap, and before July 1st, it's $684 per week or $35,508 a year. Starting January 1st, 2025, $1,128 per week, $58,656 per year. So $20-some thousand increase in that salary basis.
Yeah, which is significant. It's very significant. And, the last time they made the changes, I believe, was in 2017 to the salary threshold, which prior to that, it had been $455. And it had been that number since, I believe, the 80s. So it had been a very long time since they had made those changes. And the reason why I said, we'll talk about whether or not that's going to happen is that there was an aggressive number, I think, like an $800 number that they had originally proposed, $800 a week-ish number that they had proposed in 2017. Yeah. And then a court out of Texas put an injunction on that. And I think it was almost a year before they made the adjustments and put it into place. And so I know that there are a lot of people who went through the 2017 event and believe that because of the significant increase, that there's a likelihood that we may see some changes, even though it's a final rule, that we may see some changes. I mean, of course, we don't know, but there are definitely some people who are thinking we may see some changes, we may see an injunction. And I will tell you, the last time, that injunction was like 5 days before it went into effect. Yeah. So many businesses had already made the changes. As a consultant, I had already converted many of our clients over. And then it was injunction. And they were like, well, we've already made these changes. Yeah. So with that being said, of course, businesses need to prepare and plan for that. So as we think about, what that looks like, what are some of the impacts to businesses as it relates to these changes?
So the main impact is going to be deciding whether you're going to raise the employee's salary to meet these new salary basis tests, or whether you're going to convert them back to non-exempt and pay them overtime. So a big piece of this is going to be, well, does your employee work more than 40 hours a week? Question that's sometimes hard to answer if you're not tracking hours, because one of the things that is true of exempt employees is that typically they're not recording their hours, because the reason to record hours is for overtime calculation purposes and those types of things. So people should have a sense of whether their employees are working more than 40 hours. And if they are, they'll need to take a look at it and calculate and say, all right, well, if I did have to pay them overtime, what does that look like versus raising their salary?
Yeah. And so I was speaking to a group of, this is a very specific group of people. I was speaking to a group of CFOs for country clubs. It's a very specific group. But they are a very seasonal type of organization, right? And so one of the questions that they had was like, during golf season, their golf pros work a lot of hours. But when it's not golf season, they don't work a lot of hours. And they were like, well, how do we manage that? So a couple of things that we talked about was the fact that someone's salary today, you don't necessarily have to convert them to the hourly equivalent of what they're making right now. Because ultimately, if you're like, this person makes $75,000 a year in the salary, if they're going to work overtime, most likely for 3 months, their hourly equivalent when you're planning doesn't necessarily have to be $75,000 divided by 2080. It could be any number that you decide so that you can average at the end of the year a take home of $75,000 a year. So if you anticipate 20 hours a week of overtime for 3 months, you can kind of back into the hourly rate number that you may feel would make their end of the year. So it's kind of also like a numbers game. So you don't have to give them the hourly equivalent of their salary when you convert them to hourly, if you believe that they're going to work a lot of overtime, because it's not intended to give people an inadvertent raise, right? If you want to give them a raise, you can, but it's not intended to give them an inadvertent raise, right? So some of the things that organizations can think about is, okay, how do I plan financially to make sure the end of year number is what it needs to be? Because if I know they're going to be working overtime, which again, you should have a sense of, then you've got to do the math to figure out what does that number look like. And maybe it's, $25 an hour instead of $32.50 because at the end of the year with overtime included, it's still going to average out. So, I think that it's important for businesses to understand that it doesn't have to be an exact salary equivalent when you convert them, but you want to make sure that you're being fair to the employee, you're communicating to the employee what the intentions are, and that your intent is to have their end of year still be the same.
Yeah, well, I think that brings up some good points about the practical implications of this, because in addition to the financial, you also want to think, well, you've had an employee that's been on salary the whole time, and people equate a certain status with that, or a certain thought around that, about not having to clock in and out, about not having to clock out for lunch, or these different these different practices that are related to being a non-exempt employee and having to track hours. And so there is a practical component as well when you're looking at that and saying, well, is there how am I going to communicate to the employee to let them know that things haven't really changed, but this is just a little bit more of an administrative piece? Or how am I going to make sure that they don't feel like this is a negative change or a negative impact to them? And because it can just be an administrative burden as well for some industries as well. So is it very challenging for you to have that person based on their role clocking in and out and tracking their hours? And because ultimately, if you are going to make them non-exempt, instead of raising their salary, you need to be tracking their hours. That burden's on the employer. If they come to you and say, well, I worked 30 overtime hours every week for the last year, and you don't have them clocking in and out, you're going to be in a world of hurt.
Yeah, absolutely. Absolutely. And also there are different timekeeping methods. So, you may have certain individuals in the organization by job title, by job classification that use a time clock. And perhaps that's what they need to do. And then there may be certain individuals that use a timesheet. So perhaps there's also a way to soften the blow a little bit by how you capture the time. You do have an obligation, to your point, to track all the hours that they worked in that work week and pay them for those hours. But perhaps and as long as you're not discriminatory in this manner, meaning that the types of jobs, right? As long as you're not discriminatory in how you make that selection, if you have individuals that are doing certain types of work, maybe that are doing more tactical work that can need to clock in and clock out, go to a central location. And then you may have people who are a little bit more independent, who used to be salaried, where a timesheet may be a little bit more appropriate for capturing time. So there's also different ways that you can capture the time to help manage the blow. But the communication, to your point, and also training them that they have to record all of their time. They can't do off the clock work. And also thinking about the fact that people who used to be exempt probably have their email on their phone. Mm-hmm. They're used to checking their email all the time. I tell you, my screen time tells me all the time, your screen, you spent X number of hours on your phone this week, and I know 90% of it was checking email, right? So, those are all things that we need to consider, that businesses need to consider when doing that type of, having that type of conversation and making that type of conversion. So additionally, with that, aside from, the timekeeping, making the adjustments, what are some other changes that employers may need to consider, maybe policies or other practices that they may need to consider?
Yeah, so always when you're talking about exempt versus non-exempt, this is a good opportunity to just audit your practices, I think, generally. I am a big believer in if you're under the hood already, let's take a look. Because a lot of folks, every once in a while I'll have a client, and this gets back to your comment about the name of the administrative exemption and the confusion there. Every once in a while I'll have a client come to me that has 50 employees, let's say, and they're all exempt. And that's very confusing to me because I don't know of really any businesses of that size that should have all exempt employees, right? Yep. So it's a good opportunity to definitely shore up those policies, check your handbook, check how you're describing exempt and non-exempt employees, double check the roster in addition to the salary and checking those numbers. Also saying, all right, let's let's see if we're meeting the job duties test. Are these people still doing what classifies them as an exempt employee? Just a good time for a checkup. And to your point earlier as well about how often these things change, stay up to date on what's happening, because things do change. These folks who are making the decisions, it's very politicized. And as you mentioned, there was a huge gap between like the 80s and just not that many years ago, the last time that this changed. And so there's been a lot of work trying to, because it went so long without a change, now there's been so much change recently. And I'm sure we'll continue to see things ebb and flow and adapt, in addition to what we're seeing right now.
Yeah, and actually they've decided to index it. So, every 3 years they're going to revisit it and adjust it. So, which is, however you feel about it. I mean, I'm not a fan of indexing, but what I will say is that rather than going 20 years and then 6 years and then keep doing these huge jumps, if we can anticipate and plan for the fact that in 3 years we're going to see some changes, at least we can be prepared. Yeah. So to that extent, I'm okay with it, but I have feelings about indexing things. Yeah. So I think, also with, these changes, it's also important for businesses to, like I said, like you said, to, when you're under the hood, continue to do that assessment. And I know that people don't like going to the government websites and don't like using them, but I will say that the DOL of all the initials has a pretty good website. Yeah. They have really good resources. And if you have questions about the duties test, there's, some things that you can walk through to see, okay, could this potentially pass muster, right? It's not, a fail-safe, and I definitely encourage, everyone to get an attorney or an HR consultant. But if you want to just go in there and see, it's anonymous. You can go in, you can answer some questions, and it'll just give you feedback, right? And so I definitely encourage, at a minimum, for people to go out there, look at the fact sheets. The DOL has some really great fact sheets about and now they're ahead of themselves. They actually have updated it already for the new stuff. So there's all the new rates and everything that are already out there on the DOL website. So there are some great resources that are out there to help businesses and employers to, stay informed, to keep themselves updated, and to kind of gut check themselves if they don't have a professional already to help them. But when it comes to that as well, I would also say that this is also a time to double check whether or not you have people classified as employees or independent contractors at this point. Because as you said, we run across clients as well. Everyone's, salaried. I'm like, how? And then we run across people like, oh yeah, I have 2 employees and everybody else is a 1099. I'm like, how? And particularly because, the DOL came out earlier this year with the independent, contractor final rule as well. And so it's like we have a lot of things that have changed this year and a lot of guidance. So I think that also looking at whether or not you have people classified correctly as employees, because then you'll have to go through that test if you decide that they're an employee as well. So we've talked about the Fair Labor Standards Act. We have sufficiently scared people into knowing that these things are going to happen. But there have been some other changes as well. So the FTC, which for me is very interesting. I don't know. Maybe I don't understand how it all works, but I just found it very interesting that the FTC was the one that came in and said that there were going to be changes to the non-competes. It was the FTC, right?
Yeah.
Okay, I was going to say, did I say that wrong? Okay.
Yeah, no.
And so the non-competes, talk to us about the changes in the regulations for the non-competes.
Yeah, and I think you really nail it there, because it is unusual for employment folks to be talking about the FTC.
Yeah.
It is not uncommon for us to talk about the DOL, the EEOC, the National Labor Relations Board. There's all these different, ones that we spend our time on.
Yeah.
The Federal Trade Commission is not one that we typically have to be involved with.
Right.
But recently there was a final rule that came down from the FTC on unfair competition. And so they are using Section 5 of the Federal Trade Commission Act around unfair trade practices to ban all non-competes nationwide. This has been an interesting development because on the state level, there's already been some states acting in this direction. Courts have very much been disfavoring non-competes for a long time. And I should clarify in talking about this, a lot of folks will lump non-competes, non-solicitations all together in their head as a non-compete.
Right.
And the broader category is restrictive covenant is how we refer to it. And that'll encompass any type of restriction on employees like non-solicit, non-compete, non-disclosure, even confidentiality can be up under those types of restrictions and covenants. So anything that's restricting employees in an agreement. This rule is very focused on non-compete specifically, which think you won't compete with me in a 30-mile radius. You won't go work for my competitor down the street. I mean, those are the types of language that we're talking about, as opposed to a non-solicit, which is you won't take my clients when you leave. You won't take your colleagues when you leave.
Right.
And those types of restrictions. Or you won't disclose confidential information. You won't disclose, our customer sheets, those types of things. So this is really focused on non-competes. It's going to be effective September 4th. We think.
Yeah.
There's already been several challenges to this as far as the overreaching nature from a constitutional perspective. 2 cases filed in Texas and 1 in Pennsylvania. I do think we might see a few more as well. And they will be seeking an injunction to stop this from going into effect September 4th until this can be sorted out in the courts and the constitutionality can be tested. And that'll probably take 12 to 18 months unless it's on an expedited track.
Yeah. And it's interesting to me because we do live in a federalist society, so the states can make their own decisions, right? And so it's interesting to me the things that the federal government decides to weigh in on versus the things that they say, we'll let the states decide on. I'll leave that there. But to your point, states have weighed in on non-competes. Maryland has been very much they have a lot of opinions on non-competes. Maryland does. And so the fact that now we have a federal regulation that's now stating, a federal ruling that's now stating that, pretty much it doesn't exist. So can you help us understand the limitations that have been outlined by this final rule?
Yeah. So it's a blanket ban. It's pretty broad, actually, with very few exceptions. And when it goes into effect, it will essentially eliminate most non-competes that are in place, except for non-competes that are in place for senior executives. It won't stop people from prosecuting violations of a non-compete that happened before the rule went into effect. So if you have a non-compete right now, someone breaks it tomorrow, and then you start pursuing that in court, you still can continue to pursue that. So when the rule goes into effect, it's going to be no more non-competes moving forward for employees. And then you're only prosecuting violations that happened prior to that date. And you also have to notify the employees who are subject to a non-compete that it's no longer valid. So there's some onus on the employer there to figure out who they have under non-competes. The only other exception, so I mentioned the senior executive exemption briefly in passing here, that even though all non-competes that are already in place when the rule goes into effect will essentially be obsolete, that does not apply to senior executives. Senior executives, there is a salary threshold. I believe it's around $151,000. They have to be making to be constituted a senior executive. They also have to have policy-making authority. And there's a detailed rule within the, 100-page final rule of this, right. All the guidance that they provide. But those can still be in effect. You just can't but you can't make any new ones after September 4th. Another exemption is business non-competes. So if people might see this in the context of an M&A deal where 2 businesses agree not to compete with each other, they're still permissible in those contexts.
Okay. And, I think, thank you for the clarification about the restrictive covenants as a blanket versus non-competes themselves. Because I think that outside of sales organizations and certain other types of businesses, most organizations are focusing on non-solicitation and confidentiality. And I think those are pretty standard just in general in organizations. Non-competes, have their place in other organizations. So as it relates to proprietary information, as well as, intellectual property. And the thing is that intellectual property, not necessarily meaning a tangible thing, right? But a process, a way that people do things. In my business, we have unintimidated HR, which is the way we do things, right? And, if I can't say to people, you cannot go and do HR consulting somewhere else in the next 60 days. In the next 6 months or whatever it might be currently in Maryland. What does that mean for employers as it relates to, no, you didn't take my client list, you didn't take people, but you took the essence of what makes us us, because now you know the secret sauce. It's like, understanding the 12 flavors or however many flavors in Kentucky Fried Chicken.
Yes.
How do employers manage through that?
Yeah, I like to use the everlasting gobstopper from
Willy Wonka.
Because for whatever reason that gives me such a clear image of someone just really nefarious, like trying to take something. But no, so I think it's really important in the light of all of this, regardless of whether this is going to go into effect September 4th, what's going to happen in the courts. At the end of the day, you're right. A lot of our clients are more focused on non-solicitations and other things at this point, just because of what's been going on at the state level and within the courts already. So, we've been very focused on making sure our clients are protected in other ways. You mentioned IP, confidentiality. There's other ways to try to protect your property, your other types of rights that employers have. And so this is, again, another opportunity. We'll just keep seeing these as opportunities.
Yes.
We'll stay on the positive side.
Yes.
Maybe the Aperol Spritz is making me feel positive. It's a very sunny looking drink, right?
It is a sunny looking drink, yes.
But, it's, again, another time that we can say, all right, well, let's look at your agreements, your employment agreements. Do you have your intellectual property covered? Do you have work made for a hire clauses in there? Especially if you're in an industry, everlasting gobstopper, you're in some type of thing where you've got actual secret sauce and secret ingredients. You really should make sure that all employees are subject to other types of restrictions. So it's a good time to go in and see, well, where else can I shore up agreements and just in practical, are there people within your organization that have access to too much? Should they have access to less? And should there be a better understanding on what they can and can't do with things that they take, they might want to take with them when they leave?
Sure. And I know that, your goal is not to give free legal advice here, but one question that I do have is, as you think about, and I know there are certain things that you can trademark, certain things that you can, protect from a patent perspective, right? So at what point should organizations, if they have a secret recipe or a secret sauce or a thing, can those types of things protect them in any way? I think about that for myself. I've thought about, should I trademark certain things? I don't know. And now that we're in this place, it makes you ask the question, how do you protect yourself if it's not through a non-compete? Can you share if there are any options for people?
There's a lot of things that you can protect that I don't think people always think about or realize. I think it's always good advice, just even separate from this conversation, to talk to an intellectual property attorney and find out where those limits are and what you can protect. Because in addition to it protecting you from an employee who might want to take and use your name, your likeness, your secret sauce, your whatever it might be, it can also be a source of revenue. So if you do want to, there's strategies around that as well. You develop, I see this a lot in with clients that develop programming or lessons or different types of presentations, or that might be their industry. Or we even see it in, hairdressers, because like with Instagram, right, we've got everyone's posting their pictures of their clients' hair online, but when they leave, is whose property is that, right? So it's something that's a best practice, and even in industries you're not thinking about it, the everlasting gobstopper or the, the secret sauce or these things. Those are easier to think about because that makes sense, and that's what we think of when we think about intellectual property rights and other types of protection. But it's really present in a lot of industries. People's name, Barbie trademarked the Barbie pink color, right?
Yeah.
So, and those ones are interesting. I work with a lot of IP attorneys, and their area of work is really fun.
Yeah.
In most instances, whether it be patent or trademark, but those are good things to always explore.
Okay, awesome. Well, we have covered a lot today.
Yes.
Lots of fun topics for employers to ponder. Is there anything else that we didn't talk about today that you think that people should know about?
I think that you touched on something earlier that I just really want to emphasize, actually, which is the guidance online for employers from these lettered agencies, right? So it can be daunting and they can be long, that we talked a little bit about how big these final rules are and things. And obviously hiring, folks like ourselves who spend a lot of time reading that before bed and in the morning and at lunch, reading all of this guidance, we can definitely be a big help. But there is good guidance out there. Whenever new guidance comes out, I think a lot of times employers will roll their eyes and be like, oh gosh, more guidance, more things I have to deal with. Well, actually, it's those agencies telling you, here's what we're paying attention to, and here's what we're not. They're giving you the guidance. It's called guidance for a reason.
Yes.
And even if you don't agree with it, and even if you're frustrated by it, it will tell you what you need to do or not do. So I just think that was a really great point that I wanted to emphasize.
Awesome. Well, thank you. And thank you, Sarah, so much for joining us today. We really appreciate it. Your insight is very valuable, and the information that you've shared is very valuable.
Thank you so much for having me. I had a great time.
Yes, absolutely. And thank you for joining us for this episode of HR and Cocktails.